Hello, my name is Major Russ Guilfoyle. Today we are going to cover the law of war, specifically the rules that govern the conduct of soldiers in military operations. However, in this brief, I will refer to the law of war as the Law of Armed Conflict, or LOAC, because currently the United States Congress has not declared war on any nation. In fact, the U.S. Congress has only declared war in the War of 1812, the Mexican-American War, the Spanish-American War, World War I, and World War II. You can think of the terms the law of war and the law of armed conflict interchangeably, because substantially all the same rules that would apply in war would also apply in an armed conflict that is not a declared war. It is important to understand why we are here. The Geneva Conventions of 1949 require that all members of each ratifying nation's military forces be trained in the law of armed conflict. Furthermore, DoD Directive 2311.01, updated in 2020, establishes the DoD Law of War program. This directive requires all service members to comply with the law of war in good faith, refuse to comply with clearly illegal orders to commit violations, and report any potential violations in accordance with the directive. Paragraph 2.7 Bravo directs the Secretary of the Army to provide the necessary instructions so these principles are known to all members of the Army. This knowledge must be commensurate with your specific duties and responsibilities. This session specifically fulfills the pre-deployment training requirements listed in Army Regulation 350-1, Table C1. Training objectives. Our objectives for this hour are as follows. First, we will cover the history and legal sources of the law of armed conflict. Second, we will discuss the fundamental reasons why these laws exist. Third, we will dive into the four basic principles: military necessity, distinction, proportionality, and humanity, also known as the prevention of unnecessary suffering. Finally, we will apply the 10 LOAC standards, also known as the Soldier's Rules. The concepts we discuss today are not new. They are rooted in thousands of years of human history. We see early traces in the Code of Hammurabi from 1754 BC that codified the difference between intentional and accidental harm and emphasize the concepts of proportionality and responsibility. The ancient Greeks distinguished between combatants and non-combatants, like heralds and envoys. Sun Tzu's The Art of War speaks of treating the enemy humanely to reduce resistance. Through the ages, the Mahabharata, Roman laws of war, the Islamic law of armed conflict, and the Code of Chivalry provided a framework for honorable conduct in warfare. Modern legal theory began to solidify with Hugo Grotius's De Jure Belli Pacis in 1625, and Britain's Mutiny Act of 1689. The history of the rules of war led all the way to America, where the United States played a pivotal role in codifying a modern set of rules called the Lieber Code. The Lieber Code, issued by President Lincoln on April 24, 1863, was the first modern codification of the laws of war, written to guide Union forces during the U.S. Civil War. It was authored by Franz Lieber, a German lawyer, political philosopher, and combat veteran who taught at Columbia Law School. In the late 19th and early 20th centuries, the parties to the Hague Conventions of 1899 and 1907 used the Lieber Code as the basis for international legislation on the law of war. Since the Lieber Code, the rules of war evolved into international laws called treaties to be respected by many nations, beginning with the Hague Conventions, then the UN Charter of 1945, the Nuremberg and Tokyo trials following World War II, and the Geneva Conventions of 1949. The table on the right lists all the treaties and conventions regulating the law of armed conflict that the United States has signed. As a reminder, treaties, to include conventions, are treated as the supreme law of the land under Article 2, Section 2, Clause 2, called the Supremacy Clause of the Constitution, which reads, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. And here are more treaties and conventions signed by the U.S. regulating the law of armed conflict. In total, there are 26 treaties and conventions ratified with 3 more signed, but not ratified. I hope at this point you begin to appreciate this briefing as the culmination of thousands of years of evolving rules in war and the content of 29 treaties and conventions, distilled into a 50-minute briefing. Count yourselves lucky you are not required to read and know all these, in addition to your Army regulations, field manuals, and technical manuals. So finally, what exactly is the law of armed conflict? It is a combination of international law, including all the treaties and conventions just listed, along with customary international law, which are the traditions, customs, and norms of the global community, combined with domestic law, such as the War Powers Resolution Act of 1973, which, for example, limits the power of the president by requiring consult with Congress before using the military in armed hostilities, as well as reporting requirements to Congress and a time limit on the use of armed forces in hostilities without congressional approval. That's one answer to what the law of armed conflict is, a long answer at that. Another answer to the question, what is the law of armed conflict is? It's part of who we are. All the way back to the beginning of America, George Washington, as Commander-in-Chief of the Continental Army, agreed with his British adversary that the Revolutionary War would be, in quote, carried on agreeable to the rules which humanity formed, end quote, and, in quote, to prevent or punish every breach of the rules of war within the sphere of our respective commands, end quote. George Washington thought them important, so should you. The law of armed conflict and the rules of engagement, ROE, are intrinsically linked, with the law of armed conflict as the international legal framework that binds all parties in war, and the ROE acting as mission-specific, policy-based directives that guide, restrict, or enable the use of force. ROE must comply with LOEC principles, but can be more restrictive to meet political or mission objectives. Importantly, the law of armed conflict applies to all signatory nations, while the ROE is determined within a combatant command. Your ROE might violate the ROE of another command, but both must comply with the law of armed conflict. Now we know what the law of armed conflict is, but why do we really need it? Is it just about rules? These laws assist commanders and soldiers in mission accomplishment. The law of armed conflict is inspired by the desire to diminish the evils of war by 1. Protecting both combatants and non-combatants from unnecessary suffering. 2. Safeguarding certain fundamental human rights of persons who fall into the hands of the enemy, particularly prisoners of war, the wounded and sick, and civilians. And 3. Facilitating the restoration of peace. Furthermore, adherence to the law of armed conflict promotes a disciplined, effective fighting force and ensures support for U.S. operations at home and abroad. It leads to better treatment of our own soldiers and civilians and leads to earlier ends to hostilities. It's also the right thing to do. As you will soon learn, there are 4 principles to the law of armed conflict, and, in my opinion, they track pretty close to common concepts of morality. Okay. That's why we as a nation and we as an army need the law of armed conflict. But what about me and you? Why do you need to follow the law of armed conflict? It's baked into the Army values. Loyalty to the United States values, articulated in the Declaration of Independence and Constitution that all people are created equal and deserve the dignity of due process of law, as well as life, liberty, and the pursuit of happiness. Duty, to follow the law. Respect for your fellow humans. The selfless sacrifice, integrity, and courage of living not for yourself, but for the values you hold dear. And before you tell me I forgot one, I am saving honor for last. Honor is what distinguishes you as a professional soldier instead of a criminal. Honor is what makes us a lethal profession as opposed to a dangerous mob. I'll end the answer of why do you, need the law of armed conflict with a reading from Brigadier General Telford Taylor, lead prosecutor of the Nazis at Nuremberg. He says of the law of armed conflict that, in quote, mankind is very much better off with them than without them, end quote. And they are, in quote, necessary to diminish the corrosive effect of mortal combat on the participants. War does not confer a license to kill for personal reasons, to gratify perverse impulses, or to put out of the way anyone who appears obnoxious, or to whose welfare the soldier is indifferent. War is not a license at all, but an obligation to kill for reasons of state. It does not countenance the infliction of suffering for its own sake or for revenge, end quote. And finally, citing the Lieber Code and saying, in quote, men who take up arms against one another in public war do not cease on this account to be moral beings. So what happens when the law of armed conflict is violated? It can lead to significant disadvantages for the United States, advantages to our enemies, and a great cost to yourself. Loss of legitimacy and strategic credibility. For example, the My Lai massacre during the Vietnam War significantly damaged our support abroad, at home, and in theater with the local population. As a reminder, at My Lai, between 347 and 504 civilians, almost all women and children and elderly men, were murdered by U.S. Army soldiers, with some of the women and children being raped and their bodies mutilated. Operational and tactical setbacks. The Haditha killings of 25 unarmed civilians by U.S. Marines in Haditha, Iraq in 2005 had a similar effect as My Lai, causing a loss of trust with the local population, and the outrage increased to hostile activity, all resulting in setbacks for U.S. operations. Breakdown of discipline and command climate. In 2006, 5 members of the 101st Airborne Division raped a 14-year-old Iraqi girl, killed her, her parents, and her younger sister. The lack of discipline this demonstrates is striking. After the crimes, the unit was divided between the whistleblower who reported the incident and the perpetrating soldiers who said they didn't do it. The command climate fostered retaliation against the whistleblower until all was revealed. Legal, financial, and institutional consequences. Needless to say that violations of the law of armed conflict lead to severe personal consequences. Soldiers were court-martialed in the My Lai massacre, Haditha killings, Mahmudiyah rape and murder, and most other cases, to include this famous example, Balangiga massacre during the Philippine-American War in 1901, where Brigadier General Smith ordered his soldiers to kill everyone over the age of 10. He and his subordinate, Major Walker, were court-martialed. Alliance fracture and diplomatic isolation. In 2015, U.S. aircraft struck a hospital, killing 42 staff and patients. The attack drew immediate condemnation from global leaders and humanitarian organizations, leading to demands for an independent investigation under the Geneva Conventions. The attack severely strained relations between the U.S. NATO forces and humanitarian NGOs, specifically undermining trust in the deconfliction process. Information warfare and historical memory. The Abu Ghraib prisoner abuse, discovered in 2004, was a clear win for the Iraqi insurgency, Al-Qaeda, and later the Islamic State of Iraq and Syria, who heavily utilized the abuse scandal for recruiting purposes. The images of the abuse served as a powerful propaganda tool to fuel anti-Western sentiment and increase the hostilities against U.S. personnel. Furthermore, it undermined U.S. credibility that we were bringing human rights and the rule of law to the region. The scandal continues to be used as a reference point in international affairs, with later actions by U.S.-backed forces being viewed through this lens. When it comes to the law of armed conflict, you are required to comply in good faith. To refuse to comply with clearly illegal orders to commit violations of the law of war, and report actual and potential violations. When it comes to war crimes, I was just following orders is not a defense. Nor is, but they did it first, or they're doing it so I will too. We all know that 2 wrongs don't make a right, and that when someone does something wrong to you, that does not give you the right to do something wrong to them. Furthermore, DoD Directive 2311.01 Echo and Army policy require you to report known or suspected violations of law of armed conflict to your chain of command, whether committed by U.S. or other forces. Your chain of command will initiate an investigation into what happened. If you are not comfortable going through your chain of command, go to the JAG, the IG, or the chaplain to report the incident. These are the four cornerstone principles of the law of armed conflict: military necessity, distinction, proportionality, and avoiding unnecessary suffering. The first principle and the last principle complement each other: the need to use military force versus humanitarian concern for the civilian population. The middle two principles are more tactical: shooting at the enemy, not civilians, and balancing military need versus civilian death, injury, and property damage. Let's discuss each in more detail. Let's start with military necessity. For over 150 years, since the U.S. Civil War, U.S. Armed Forces have followed the principle of military necessity. It requires two things. First, that a use of force is not illegal, and second, that a use of force is for a valid military purpose. The law of armed conflict absolutely prohibits certain acts, such as killing prisoners of war or taking civilian hostages, no matter how much it seems necessary. For all other uses of force, there must be a valid military purpose. FM 6-27, paragraph 1-23, is where you will find the Army's definition of military necessity. Military necessity is, in quote, the principle that justifies the use of all measures needed to defeat the enemy as quickly and efficiently as possible that are not prohibited by the law of armed conflict. This is a common sense principle with limits. Your actions can't be illegal, and they must be justified. Some of you may think, what does that even mean? How can something be a military necessity but illegal? It's because we are a nation of laws that supersede military necessity. So even if using human shields, cluster munitions, or anti-personnel landmines may seem like a military necessity in a given situation, they are prohibited by law. When making decisions, use your best judgment. It is U.S. policy that any decision by any military commander, military personnel, or any other person responsible for planning, authorizing, or executing military action shall only be judged on the basis of that person's assessment of the information reasonably available to the person at the time the person planned, authorized, or executed the action under review, and shall not be judged on the basis of information that comes to light after the action under review was taken. Always remember that no matter how urgent the situation, military necessity is not a defense for violating the law. Here's a hypothetical. The point of this is not necessarily to answer correctly, but to think correctly. Learning all the answers to all the hypotheticals without knowing how to assess a situation correctly will not help you in real-life situations, where the possible differences in facts is infinite. Also, feel free to pause the video and think or discuss amongst yourselves. Let's get started. Your unit calls fires on certain bridges and road networks used by the enemy units to move troops and supplies, and are also part of the civilian infrastructure in peacetime. Military necessity? But what if the enemy troops were medics and the supplies were medical supplies? Still military necessity? What if instead the destruction was necessary to isolate enemy forces, shorten the conflict, and reduce overall casualties? Still a military necessity? Would your answer be different if both what ifs were true? Let's do another one. Your commander orders your unit to clear a village suspected to be a base for insurgents. Upon arrival, your unit finds only women and children. Your platoon leader orders you to burn the village down. military necessity? But what if the women were armed and engaged your unit? Is there military necessity now? But what if no one was armed, but burning the village would send a message not to aid insurgents? Is there military necessity here? Let's now move on to the principle of distinction. Distinction, sometimes called discrimination, obliges parties to a conflict to distinguish principally between the armed forces and the civilian population, and between unprotected and protected objects. Distinction may be understood as encompassing two sets of reinforcing duties. Parties to a conflict must apply a framework of legal classes for persons and objects by 1. Discriminating and conducting attacks against the enemy, and 2. Distinguishing a party's own persons and objects. Soldiers have a duty to conduct operations so as to minimize the likelihood of civilians being attacked by enemy forces. Soldiers also have a duty not to intentionally occupy, absent imperative military necessity, certain civilian objects such as mosques, churches, and cultural sites. This area of the law is subject to detailed rules. Your rules of engagement may provide more specific guidance tailored to local cultural and operational circumstances. Distinction isn't always simple, but often it is. Target only military objectives. What is the easiest way to practice this? Positive identification. How are you verifying your target? Are you in contact with someone in the air or on the ground who is observing the target? Are you sure you are looking at the right person, place, or thing? On today's battlefield, the type of equipment may not be dispositive in determining whether an object is military or civilian in nature. Seeking current intelligence and being deliberate in target identification verification is key. There is an inverse to this principle as well, and that is we, as combatants, must distinguish ourselves from civilians to allow civilians to be identified. Carry your arms openly, wear uniforms, mark equipment to identify it as U.S. Army. These are all efforts to comply with the principle of distinction. This is not to be confused with camouflage or cover to mask positions from the enemy. That is perfectly legal and tactically imperative. Let's do a hypothetical. Your unit is taking fire from a residential area, both indirect and direct. Is the enemy violating the principle of distinction? But what if there were no feasible alternatives nearby to base the enemy's attacks? Does this violate the principle of distinction? What if you tell your unit to fire at every open window in the area? Are you violating the principle of distinction? Let's do another. During counterinsurgency operations, you observe an individual on a rooftop using binoculars and a handheld radio. The individual is wearing civilian clothing and is located on an apartment building overlooking a main supply route, frequently targeted by IED attacks. No weapon is visible. Lawful target? What if moments later, a convoy moving through the route hits a pressure-plated IED approximately 300 meters away? How do you distinguish the individual on the roof now? Lawful target? What if the individual gives a hand signal immediately before the explosion? The next principle is proportionality. Proportionality is the method for commanders to assess their obligations as to the principle of distinction while avoiding indiscriminate attacks. specifically FM 6-27, defines it as the law of armed conflict principle requiring combatants to refrain from attacks in which the expected loss or injury to civilians and damage to civilian objects incidental to such attacks would be excessive in relation to the concrete and direct military advantage expected to be gained. When thinking about this principle, the emphasis is on the consideration of avoidability, excess in relation to anticipated military advantage, and international law. Before attacking, always consider any reasonable available information about the target and collateral damage. Take steps to minimize civilian deaths, injuries, and property damage by confirming intelligence, choosing appropriate weapons and tactics, selecting the time and manner of attack, and using processes like collateral damage estimation as appropriate to the situation, or other approved TTPs. Particularly when civilians are close to military objectives, or during aerial bombardments, consider issuing effective advance warnings, unless the attack is a surprise assault and a warning would compromise it. Operational terms and graphics in our doctrine help support this principle. They aren't just symbols. They help define the specific intent and level of force required for a mission. As with any operation, you must carefully consider what you actually need to accomplish with your respective weapon system and capabilities. To put this into a practical context, consider a mission where your objective is only to screen or disrupt a small enemy convoy. In such a case, calling in a massive fire mission, for example, 100 rounds of 150 millimeter high explosive fire for effect, would likely be unnecessary and excessive in relation to the military advantage gained. The goal is to apply the necessary force to achieve the mission while minimizing collateral damage and avoiding the use of excessive means. Here's our first hypothetical. A unit identifies an enemy weapons cache stored in a small warehouse located 50 meters from a residential compound. The cache includes mortars and rockets used against friendly forces. ISR confirms civilians are currently present in nearby homes, but not inside the warehouse. What is the right tool for the job? What if there are only civilians in the area, no enemy combatants guarding the cache? What's the right tool for the job now? What if instead all the civilians will clear out in 2 hours? They all work at the market. Does this change the right set of tools? Here is another. A patrol is pinned down by enemy fire from a multi-story apartment building. Enemy fighters are firing from several windows. Civilians are believed to be present on lower floors, but their exact number is unknown. What is the right tool? What if the patrol can retrograde and reroute around the building? What's the right tool now? What if instead insurgents are pinned in as well and running low on ammunition? What's the right tool? The last basic principle of the law of armed conflict is humanity, which means to avoid causing unnecessary suffering. Humanity may be defined as the principle that forbids the infliction of suffering, injury, or destruction unnecessary to accomplish a legitimate military purpose. Humanity is related to military necessity, and these principles logically complement one another. If certain necessary actions are justified, i.e., military necessity, then certain unnecessary actions are prohibited, i.e., humanity. An application of humanity is that all issued military weapons and ammunition are subject to a legal review for compliance with the law of armed conflict. Here are 3 examples of prohibitions based on the consideration of humanity. 1. Never to use certain weapons in warfare, like glass-filled projectiles. 2. Restrictions on the use of some weapon systems to better protect civilians and soldiers, like incendiary weapons and fragmenting bullets. 3. Prohibitions on the use of any weapon in a manner calculated to cause unnecessary or gratuitous suffering that has no military purpose. Example: a sniper aiming deliberately for one kneecap, then the other, purely to see the victim squirm. Know that the U.S. always conducts a legal review of weapons before they are fielded. Make sure you know the rules regarding every fielded weapon in your arsenal. Seek advance approval from higher for any modification that changes the design or intended use of a weapon. Understand that shooting and wounding an enemy soldier is not prohibited. The key element is your intent. If you shoot an enemy in the leg so you can capture him, or because you don't shoot well, that's permissible. Shooting an enemy in both knees and leaving him to crawl through dangerous terrain for the sake of suffering is not permissible. We all know that suffering is a fact of battlefield life, but only when necessary. This principle forbids unnecessary suffering caused by illegal or improperly modified or used weapons. The desire of the principle of humanity is to minimize, though can never eliminate, the overall violence of war. Here's a hypothetical. What if a sniper tasked with neutralizing an enemy commander has two types of ammunition available? Standard full metal jacket rounds intended to pass through or lodge in the body to incapacitate the target, or serrated tungsten-tipped rounds that cause difficult-to-treat wounds. Which should be used? What if the enemy commander is wearing a type of body armor that stops full metal jacket rounds? What if in fact the tungsten-tipped rounds are the only ones available? Let's do another. An infantry unit is approaching an enemy bunker. They need to clear the bunker in advance. Their options are smoke grenade, incendiary grenade, fragmentation grenade, flamethrower, or chemical agent. What should they use? What if the enemy had previously used chemical agents against U.S. troops? What if the enemy had gas masks and a protective barrier within the bunker? The soldier's rules, found in the previous 2017 version of AR 350-1, Table F2, are a useful summary of the most fundamental law of armed conflict rules. The soldier's rules do not include every rule found in the law of armed conflict, but they do provide a basic law of armed conflict foundation that can be applied in U.S. military operations. Rule number 1, fight only combatants. However, commanders have an inherent right to defend their units, and a soldier's right to self-defense is a subset of unit self-defense. The inherent right of self-defense provides U.S. Armed Forces with the ability to respond with measured force whenever they come under attack. The principle of military necessity underlies the justification for using force, i.e., unit or individual self-defense, to preserve the ability to fight and win in the future. Civilians may not be made the object of attack unless they take direct part in hostilities. Combatants are the military forces of the enemy. They include members of the armed forces of a state, members of militia and volunteer corps, participants in a levée en masse, persons belonging to non-state armed groups, and leaders whose responsibilities include the operational command and control of the armed forces or of a non-state armed group. Combatants may be privileged or unprivileged. The privilege is to use lethal force under the compliance of the law of armed conflict. Unprivileged combatants, more technically called unprivileged belligerents, are either persons who have lost their lawful combatant status due to their failure to comply with the law of armed conflict, or are persons who have forfeited one or more of the protections of civilian status by engaging in hostilities. Hostilities include hostile acts and hostile intents. A hostile act is an act or other use of force against the United States, U.S. forces, and in certain circumstances, U.S. nationals, their property, U.S. commercial assets, and or other designated non-U.S. forces, foreign nationals, and their property. It is also force used directly to preclude or impede the mission and or duties of U.S. forces, including the recovery of U.S. personnel and vital U.S. government property. A hostile act triggers the right to use necessary and proportionate force in self-defense to deter, neutralize, or destroy the threat. Hostile intent is the threat of imminent use of force against the United States, U.S. forces, or other designated persons and property. It is also the threat of force used directly to preclude or impede the mission and or duties of U.S. forces, including the recovery of U.S. personnel and vital U.S. government property. When hostile intent is present, the right exists to use proportional force in self-defense to deter, neutralize, or destroy the threat. Finally, the fact that a combatant is unprivileged does not, however, imply that unprivileged belligerents have no rights. At a minimum, in any type of conflict, they are entitled to humane treatment and the customary international law protections. Rule number 2. Do not harm enemies who surrender. Disarm them and turn them over to your superior. It is a fundamental purpose of the law of armed conflict to safeguard certain fundamental rights of persons who fall into the hands of the armed forces, particularly prisoners of war, detainees, and internees. Treating these individuals humanely is required by international and U.S. law. It provides an incentive for others to surrender and lessens their will to resist. If our enemies believe they have no incentive to surrender because they feel they will not be treated humanely, they are more likely to resist and fight to the death. A TTP for this rule is the 5 S's for detainees: search, silence, segregate, safeguard, speed to the rear, as well as tag. Refer to DoD Directive 2310.01 Echo, the DoD Law of War Program, for more information. Rule number 3. Do not kill or torture personnel in your custody. Humane treatment is the minimum standard for all detainees. This rule often becomes relevant in human intelligence collection and interrogation. To start, torture is not only unlawful, but studies show it frequently produces unreliable information and leaves lasting psychological scars on those who commit it. While trained and certified personnel may interrogate, you may find yourself conducting tactical questioning, which is authorized. Keep this rule in mind, as well as knowing that tactical questioning is limited to direct questioning. Tactical questioning should be short, with at least 2 soldiers present. See FM 2-22.3 for more information. What does treating detainees humanely look like? It is providing medical treatment, food, water, shelter, basic hygiene care, and clothing. Protect detained personnel from violence, intimidation, insults, and public curiosity. Photographing an enemy prisoner of war, EPW, for the purpose of aiding in his identification is not a violation of the law of armed conflict. However, photos taken or staged to degrade or humiliate an EPW serves no lawful military purpose. This applies to soldiers and civilian employees and contractors. Also, the U.S. does not transfer detainees to foreign control if the detainees are likely to be tortured or killed. Females shall be treated with all the regard due to their sex, and shall in all cases benefit by treatment as favorable as that granted to men according to the Geneva Convention. Rule number 4. Collect and care for the wounded, whether friend or foe. Individuals who are sick or wounded and who cease to fight shall be treated humanely without any adverse distinction found on race, nationality, religion, sex, or any other similar criteria. They are to be respected and protected in all circumstances. The immediacy of this requirement depends on mission execution, self-defense of unit members, and other operational necessities present when collection and care of wounded is needed. Use common sense and your best judgment based on the tactical situation and resources available. There is no such thing as a mercy killing in the law of armed conflict. They are illegal. You have a duty to attempt to render or provide medical treatment to the sick and wounded. Respect the dead. Do not rob, mutilate, or pose for pictures with the dead. Geneva Conventions also require an examination of the body, honorable burial, which means no cremation, except for religious or hygienic reasons, and marking and recording the grave location. Individual burial is strongly preferred. However, a military necessity exception permits burial in common graves if circumstances, such as climate or military concerns, necessitate it. The reason for the examination plays a dispositive role in identifying the deceased and refuting allegations of war crimes. Thus, examinations should be conducted with as much care as possible. Rule number 5. Do not attack protected persons or protected places. Protected persons often include civilians, medical, and religious personnel. Regarding protected places in general, civilian objects such as hospitals, churches, and mosques are protected from intentional attack or destruction. However, objects may be attacked if they become military objectives. Military objectives, insofar as objects are concerned, include any object which by its nature, location, purpose, or use makes an effective contribution to military action and whose total or partial destruction, capture, or neutralization in the circumstances ruling at the time offers a definite military advantage. In circumstances that do not amount to an attack, the law of war still protects enemy property. In general, enemy property may not be seized or destroyed unless imperatively demanded by the necessities of war. There are 3 recognized medical marking emblems under the Geneva Conventions and Protocol 3: the Red Cross, Red Crescent, and Red Crystal, which has some variation. Objects or individuals marked with these symbols are to be respected and protected from attack. However, if these symbols are misused to commit acts harmful to the enemy, then the protection they afford is forfeited. Misuse includes things like taking a direct role in combat and marking armed vehicles. Do note that the fact that while sick or wounded members of the armed forces are medically treated, their weapons are likely taken by the medical staff before being turned over to proper authorities. This does not forfeit the medical personnel's protection. Rule number 6. Do not destroy more than the mission requires. Do not engage in destruction for destruction's sake. Consider effects-based operational planning and remember that in the future the mission may change and we may be responsible for rebuilding. So, as discussed earlier, limit attacks to military objectives, which may include factories producing munitions and military supplies, military camps, warehouses storing munitions and military supplies, ports and railroads being used for the transportation of military supplies, and other places that are for the accommodation of troops or the support of military operations. Rule number 7. Treat civilians humanely. Civilians are to be respected and are not to be made the subject of attack. However, this protection is not absolute and requires civilians to abstain from all hostile acts or intent. And unless the rules of engagement authorize collective self-defense of foreign forces, civilians, property, and interests, always contact local authorities to counter threats to the local population. It is DoD policy to provide these minimum treatments: no adverse distinction based on race, religion, sex, no violence to life or person, no hostage taking, no degrading treatment. You must care for the wounded and sick. Rule number 8, do not steal. Anytime property is taken, it must be accounted for with both the property owner and your command. In this case, Sergeant First Class Williams tried to use military necessity as an excuse for taking an SUV from an Iraqi. Further investigation into the incident revealed that Sergeant First Class Williams did not properly report or account for taking the SUV, and then attempted to cover up his actions when he failed to return the vehicle to its owner. This rule is about respecting people's personal property rights. No pillaging, no war trophies. Do not take their property unless for immediate military necessity or emergency. In those cases, issue a receipt for the property so the owner can track it back down or submit a claim. The exception here is contraband. Contraband can be confiscated. The classification of contraband is not made by the soldier, but by the ROE. Rule number 9, prevent law of armed conflict violations. This is part of your duty, and it takes personal courage. We are all responsible for maintaining the honor and integrity of our Army and our country. Do what you can to stop your fellow service members or allies from violating the law of armed conflict. As the saying goes, all that is necessary for the triumph of evil is for good men and women to do nothing. It is not easy to speak up sometimes, but the truth is worth telling. Ask for clarification of an order that appears illegal. Do not follow orders you know violate the law of armed conflict or are otherwise illegal. Do your best to prevent law of armed conflict violations. Rule number 10, report all law of armed conflict violations, by friend or foe, to your command. If you are not comfortable going through your chain of command, report the violation to the JAG, IG, or chaplain. When command receives the information, they will conduct an investigation. Remember, covering up or interfering with an investigation is itself a crime. Today we discussed the need for the law of armed conflict, its sources, purpose, necessity, and consequences. We also learned its 4 major principles and reviewed the soldier's rules, particularly the requirement to refuse to commit law of armed conflict violations, as well as prevent and report violations. If you have questions about the law of armed conflict, contact your servicing judge advocate. Finally, if you have any feedback on this presentation, please give it here. In particular, I am always interested in improving and increasing the hypotheticals. So if you have some in mind, share them here. Thank you for your attention and service to our country. Now, go do great things.